All right, let's begin with Steve Bannon, one of the architects of Donald Trump's political success, today failing at his own bid to stay out of jail. That is, unless this man can save him. That's attorney David Schoen, who I'll speak to live in just a moment. Look, it's been, 2 years now since Bannon was convicted of contempt of Congress for defying a subpoena from the January 6th committee. Remember that? His excuse back then, his lawyer at the time, Robert Costello, remember him from the Hush Money trial? One of the witnesses called in the defense. Well, at the time, he said you didn't have to comply because he thought Trump would assert executive privilege. He didn't. And Bannon was apparently on notice of that fact as well. Well, he's been appealing his conviction ever since that time. And up until now, the judge in this case had been kind of holding off on the sentence. But today, the judge said enough. There was no legal reason left to delay that sentence, and he told Bannon he has to report to prison on July 1st to serve a 4-month sentence. Outside the courthouse, Steve Bannon was, Steve Bannon.
But I want to say something specifically about the Justice Department. Merrick Garland, Lisa Monaco, the entire Justice Department, they're not going to shut up Trump. They're not going to shut up Navarro. They're not going to shut up Bannon, and they're certainly not going to shut up MAGA. There's not a prison built. There's not a prison built or a jail built that will ever shut me up. All victory to MAGA.
Well, Donald Trump called this an American tragedy, and he was apparently so angry that he even called to indict the January 6th committee. Remember, those are members of Congress. Bannon is part of a long now and growing list of Trump allies who have been sentenced to prison, people who stretch back to the Trump Organization days and the 2016 election and the 2020 campaign. And that includes Peter Navarro, who is currently in a Miami prison right now for the same reason, contempt of Congress. Joining me now, Steve Bannon's attorney, David Schoen. He also represented former President Donald Trump in his second impeachment trial. David, thank you so much for being here this evening. We're all trying to unpack all that happened in the courthouse today. And I want to ask you about what has been described as a pretty heated moment between you and Judge Carl Nichols. After he ordered Bannon to report to prison next month, you objected. Obviously, you are his counsel. And the New York Times was reporting that Judge Nichols responded in a way that let you know he wasn't too thrilled with your response, saying, "One thing I need you to learn as a lawyer is that when a judge has decided, you do not get up and yell at them." Look, I know you're an advocate for your client. Explain your reaction. Were you surprised by his decision to order him to go to jail?
Shocked by it. It goes against everything that he has said in this case. Judge Nichols found substantial questions for the appeal, said twice that Bannon should not be serving his time while the appeals process runs. The appeal process has not run. There's nothing about the panel decision that changed that. Judge Nichols said that the definition of willfully used in this case cannot be reconciled with the modern or traditional definition of willfully. Laura, you know, I'm a big fan of yours, but I have to correct something you said in the monologue. Former President Trump absolutely did invoke executive privilege. Nobody disputes that. Not only that, he wrote a letter before the trial started reaffirming it in case anyone had a question about it. And that's all in the record. That's different from the Navarro case. And Judge Nichols even said today, well, you know, the Court of Appeals opinion could have mentioned that, but they didn't, and so on. The Court of Appeals opinion is an abomination. They misstate the facts. They omit the facts. They leave out the primary argument. The primary argument here is that in the 60 years since this Licavoli case, which says willfully solely in the context of this statute means did you get a subpoena and comply or not comply with, no reason matters. 60 years since then, the court has, the definition of willfully has evolved. So in 2019, the court said literally, when Congress wants to say an act is criminal, then they say willfully. You must know that the act you did was illegal or wrong, or we don't attribute criminal liability to it. That's
David,
this case, and that's what Nichols had found earlier.
Let me unpack a little bit of this, and certainly I'm not above clarification if you think it's necessary to do so, but let me talk for the audience's perspective on the case you just described. And just in plain speak, this comes down to the notion of advice of counsel and whether that was a willful action by Steve Bannon to not comply with the subpoena. If it was advice of counsel, I think he wanted to argue that, listen, it wasn't a deliberate act. It was advice of counsel he was following, and that's why he didn't provide the information or respond. The court, though, did find, although they did wait some time, that their hands were tied on the idea of it had to be a deliberate, intentional act, and that was enough to go forward in this case. And so here you are, getting ready to appeal this matter, likely, I'm assuming all the way up to the Supreme Court if necessary. Peter Navarro, though, did try to appeal to the Supreme Court. What would make this instance different to you?
Peter Navarro's case is completely different. There was no executive privilege ever invoked in the case. That's what the court found. And there's no advice of counsel. Listen, the cases even before Licavoli, and in the Licavoli case, the 1961 case that Nichols says he was following, the defendant was permitted to testify as to his reasons. At the government's behest, this Department of Justice behest, Bannon was barred from testifying, Costello was barred from testifying about what happened and what their reasons were, and the jury was told they may not consider the reasons. Remember, Costello got the subpoena, not Bannon. Costello, as the experienced lawyer, told Bannon, executive privilege has been invoked, you may not comply, period. It would be against the law. It's not your privilege. But, he told the committee, if you take him before a court and the court says privilege doesn't apply or it's not this broad, he will comply fully. They decided not to do that. They went on the air, posturing and so on. They're going to pursue this criminally, and that's what they chose to do. We don't impose criminal liability. Yeah.
I hear you. Excuse me. What is the argument you would make to the Court of Appeals or the Supreme Court that you think would allow your client not to serve those 4 months in jail time? What would be a successful legal appellate argument?
Two arguments. The definition of willfully used by the Licavoli court that this court said their hands were tied by is no longer a valid definition of willfully in the criminal law, period. The Supreme Court has said it since 2015 and 2019. They said it expressly. There's absolutely no question about it. They say willfully means different things in different contexts. The threshold for criminal liability is that you knew or believed you were doing something wrong. Steve Bannon believed the only thing he could do to comply with the law was what he did in this case. That's what his lawyer told him, and that's what he was entitled to rely on. The jury should have been told that. That's number one. Number two, if you want to apply willfully this way, then you've created a separation of powers problem. Congress isn't the final arbiter when a president or former president invokes executive privilege, period. It's presumptively valid, and Congress can't decide that. Go to a court. A court could decide it, and that's what Bannon asked them to do. They refused to do it. There's a constitutional mandate to accommodate, try to work an accommodation. D.C. Circuit has said that. They refused to do it for Steve Bannon. And that's why people lose faith in the system. We have to treat people equally.
Well, Steve Bannon has argued something different than what you were describing today. He's talking about weaponization in more loaded terms. He's talking about this being an issue that is more broadly with the narrative we're hearing about an attack on Trump, an attempt to try to suppress MAGA as well. I mean, shutting down the MAGA movement, he's accused this judge of doing. This is, by the way, a Trump-appointed judge. This is somebody who was a clerk, I believe, of, if I'm not mistaken, Supreme Court Justice Clarence Thomas. He's been a partner at a number of law firms as well and well regarded. Does that undermine the arguments that you are now making?
I don't think so. He undermines his own argument. He's the one who said 5 or 6 times during the trial that he thinks Licavoli was wrongly decided, but his hands are tied. He acknowledged today that this panel, the Court of Appeals panel, hands were tied. The government acknowledged it. The government argued to them, you don't have the authority to overturn Licavoli. So nothing changed. He shouldn't have changed his bail status. Listen, it's not such a major event in the sense that all he could have done was let him out on bail until rehearing en banc is decided. In this case, what he did, though, is pull the rug out from under him because he has to file now. He's going to send a person to prison who he himself has said didn't comply, who he himself has said was convicted under a definition of willfully that simply is not consistent with the law. We don't do that. There's no reason to send him to prison now. Let this case play out. This is a misdemeanor.
I hear you, David. Of course, the judge disagrees and believes there's no more legal recourse in this action, and that willfulness and that Licavoli case you're talking about seems to stand as precedent. We'll see if an appellate court agrees with you. David Schoen, thank you so much.
Thank you very much.